Hello everyone, welcome to BYD Classes and welcome to the new session of Means 365 2023. So today we will discuss the polity sections of Means 365 for UPSC 2023. So let's begin. So here discuss the Indian Constitution and provisions and basic structure doctrine. Okay, in this section there is basic structure doctrine was in news. So what is this landmark judgment? This landmark judgment was created in the landmark Keshavanand Bharati judgment case 1973, which propounded the basic structure doctrine, completed 50 years since 1973 to 2022. What was the landmark cases of Keshavanand Bharati? This is the static portion, so you can read your own notes as well as politics section either from Lakshmikant or any other sources what you have. Okay, and what are the application and evolution of basic structure doctrine? So remember this, the judgment regarding the basic structure of the constitution. First case was Indira Gandhi versus Rajanarayan 1975. The court used basic structure doctrine first time to strike down 39th Amendment Act 1975, provision that barred court jurisdiction over election dispute. Okay, and next is Minerva Mills case 1980. In Minerva Mills case, the Parliament's power to amend the constitution must not damage or destroy the basic structure doctrine. And I'll tell you that this judgment is very important. And if you know about this in very detailed, I will make a polity sections for 2024 exam, then you can access these lectures on YouTube channel, my YouTube channel, so you can watch when I will upload polity sections, static polity sections. Okay, so next judgment was the Woman Rao case. In Woman Rao case, the basic structure doctrine will not be applicable retrospective. Okay, retrospective means the previous judgment. Next is the Kyoto Hollow 1 or Jasilhu 1992 case. Free and fair elections was added to the basic feature. And in Indira Sahni versus Union of India for the anti-defection law, or Indira Sahni case for the OBC quota, or not more than 50% reserved for the reservation of the reserved categories. Okay, so in this case the rule of law was added to the basic features. And S.R. Bommai Union of India 1994 case held that Supreme Court held that the federal structure, unity and integrity of India, secularism, socialism, social justice and judicial review were reiterated as basic features of the constitution. So we will look some points about the case 1 and the Bharati case 1973. So, case involved a petition against Kerala government for violating fundamental rights, Article 25, 26 and 31 by compulsorily acquiring land under Kerala Land Reforms Act of 1963. In this case was heard by a bench of 13 judge bench, largest formed in the Supreme Court. And what are the outcomes about these 30 judges bench of the Supreme Court? The introduction of basic structure doctrine. Basic structure doctrine upheld 24th amendment, stating that parliament can amend any part of the constitution except the basic fundamental principles given in the constitution that cannot be abrogated by the any amendment of the parliament. So remember this. And corrected judgments of Golaknath case. The Supreme Court ruled that Article 368 covered amending powers and procedure distinct from Parliament's legislative powers because Article 13 mentioned the judicial review, and if any amendment under Article 368 violated law given under Article 13 shall be void, and Supreme Court can declare these rules null and void. So remember this. And other judgments, Supreme Court upheld 25th and 29th amendments except for provisions limiting judicial review and affirmed the amendability of the Constitution's preamble. So remember this. Okay. And what is the significance of basic structure doctrine and challenges with regard to the basic structure? Significance such as serves as a check on power of parliament to amend the constitution, and it ensures that constitution remains a living document while preserving its fundamental values and principles. And these basic structure doctrine establish fundamental foundational principles in Indian constitutional law like rule of law, separation of powers, okay, federalism, etc., and ensures that federal structure of the constitution is not undermined. And basic structure doctrine, these are the instrumental in shaping Indian judiciary's approach to constitutional interpretation. So remember these significance of the basic structure doctrine. And what are the challenges with regard to the basic structure doctrine? Scope of basic structure. What are the scope? Interpretation of what constitutes basic structure is often contested with which can lead to differing interpretations and confusion. And judicial activism. For instance, in 2019, Supreme Court struck down National Judicial Appointment Commission Act to reform appointment process for the judges and conflict with the parliamentary sovereignty. For example, removing of special status of Jammu and Kashmir under Jammu and Kashmir Reorganization Act 2019 was challenged in Supreme Court on the grounds that it undermines federalism, secularism, and right to self-determination. However, Supreme Court upheld constitutionality of the act. And doctrine makes it difficult to amend the constitution even when such amendments are necessary to address changing societal needs. So the basic structure doctrine tells that any law made by the parliament which are violated The basic structure doctrine. The Supreme Court can declare these laws or these rules null and void. And what are the way forward? That Supreme Court needs to provide a clear definition of basic structure, including fundamental principles and values that cannot be amended. And doctrine must be applied consistently in all cases, not in some cases, ensuring that basic features of the Constitution are not tampered with by any organ of the state. And limiting judicial activism, courts should exercise restraint in interpreting Constitution and upholding basic structure, respecting the separation of powers and role of the Parliament. And there is a need for public awareness and participation in understanding the importance of basic structure doctrine and its impact on the governance of the country. And next is the what is ninth schedule. Ninth schedule, the recently Chhattisgarh government has urged to Prime Minister to enlist the amended reservation provisions of state, which provides for 76% reservation in ninth schedule. And what is the ninth schedule included in the Constitution? It was added by the first Constitutional Amendment Act 1951 by inserting a new Article 31B. And Article 31B states that none of the acts or regulations mentioned in the ninth schedule shall be considered to be void on the ground that they are inconsistent with any rights. This means that if any acts or regulations come under the ninth schedule, these rules cannot be reviewed by the judiciary or away from the judicial review. And Article 39B is retrospective in nature. That is, Article 39B can be retrospective, means the backward rules or acts or regulations can be included in this Article 39B. And currently there are 284 acts or laws under the ninth schedule, of which most are related to agriculture and land laws. So remember, okay. And important judicial pronouncements in the context of ninth schedule. Vaman Rao versus Union of India 1981. Supreme Court held that amendment to Constitution which was made before 24th April 1973 is valid as per the case 1 and the Bharati judgment and evolution of the basic structure doctrine. So here in one Vaman Rao case, the Supreme Court held that the Constitution which was made before amendment to the Constitution which was made before 24th April 1973 is valid, but after 24th April 1973 the amended rules is null and void. Okay, and next is IR Coelho versus State of Tamil Nadu 2007. Constitution bench ruled that ninth schedule cannot be challenged for violating fundamental rights, but can be challenged for violating basic structure of the Constitution. So it is based on the basic structure doctrine. And what are the criticisms of the ninth schedule of the Constitution against fundamental right? This ninth schedule is against fundamental rights. The ninth schedule provides complete blanket protection to central and state laws, thus hindering fundamental rights guaranteed in the Constitution. Against this ninth schedule against principle of judicial review. It deprives the courts of power to examine the constitutionality of the acts. In L. Chandrakumar case 1997, Supreme Court affirmed that power of judicial review vested in the high courts under Article 226 and Supreme Court under Article 32 is an essential feature of the Constitution, outlived its utility. Ninth Schedule outlived its utility. Primary aim of including Ninth Schedule was to safeguard land reform laws from judicial scrutiny and delays. However, over time it has expanded to encompass laws unrelated to land reforms, fundamental rights, and directive principles of state policy. A ninth schedule is tool to realize political gains. Since its inception, ninth schedule has continuously expanded and currently encompasses 287 acts, leading to demands for including more laws to shield them from constitutional scrutiny. For instance, Tamil Nadu law granting 69% reservation is included in the ninth schedule. And however, this 69% overtake the Indira Sahni judgment 1992, or violated the Indira Sahni judgment, because cross this crosses this 69% crosses the 50% quota of reserve categories. And next is the conclusion. From its inception, ninth schedule was put up as a constitutional device to safeguard land reforms laws. The provisions were significant at that point of time, but historical functioning of this provision reveals that it has worked to its exhaustion, and this necessitates a relook into its requirement. And next is the ordinance. What is ordinance and why this is in news? There has been a steady decrease in the number of ordinances promulgated by the center since 2019. Ordinance making power of the president and governor. What is ordinance? Ordinance is a law promulgated by state or central government without approval of legislature, and power to promulgate the ordinance is vested in Indian Councils Act 1861, Government of India Act 1909, and Government of India Act 1935. So these are the colonial laws, colonial act, which are mentioned the ordinance made by governor or the viceroy. And ordinance is listed under Article 123, power of the president to promulgate ordinances during recess of parliament, and Article 213, power of the governor to promulgate ordinances during recess of the legislature. And these promulgated ordinances have same force and effect as an act of legislature, but these acts are likely temporary in nature. An ordinance is valid for 6 weeks from date when next session starts. If two houses start their sessions on different dates, the latter of dates will be considered. Okay, an ordinance may lapse earlier if president or governor withdraws it, or if both houses pass resolutions disapproving it. So remember this. Okay, and ordinances can only be issued on matters on which parliament or legislature can make laws and are subject to the same limitation as parliament or legislature to make laws. And governor of a state cannot make an ordinance without the reference of the president in the following cases. So these are very important. Remember these facts. Okay, that ordinance cannot be made by the governor without the reference of the president in following cases. So first case, the bills that have similar provisions require the prior approval of the President to introduce the bill in the Assembly, and if Governor would have deemed it necessary to reserve a bill containing similar provisions for consideration of the President, if an act of state legislature containing same provisions would have been invalid without receiving President's assent. Okay, and what are the important judicial pronouncements in context of ordinance? R.C. Cooper versus Union of India 1970. In this case, the Supreme Court held that President's decision could be challenged on the grounds that immediate action was not required and the ordinance had been passed primarily to bypass debate and discussion in the legislature. And D.C. Wadhwa versus Union State of Bihar 1987, court held that legislative power of the executive to promulgate ordinances is to be used in exceptional circumstances and not as a substitute for lawmaking power of the legislature. And Krishna Kumar Singh versus State of Bihar 1994, court held that the satisfaction of the President under Article 123 and Governor under Article 213 while issuing on an ordinance is not immune from the judicial review. So remember, okay. And what are the issues to promulgate the ordinance with the ordinance making power of the President and the Governor? First issue is overuse. Formulate laws in emergency situation or when the legislature is not in the session. However, it has been overused. Yes, without the legislature, governor can promulgate the ordinance without the legislature is in session. Yes, and separation of power. The power of executive to make laws goes against the principle of separation of power, because no consent and no permission are taken from the legislature or from the executive, not a legislature but executive. And lack of clarity. What constitutes emergency situation? Necessity as a ground to pass the ordinance. Okay, and next is the accountability. The laws made by ordinance bypass the legislative scrutiny and thus hampers the basic function of the parliament. And center-state relations. Ordinance making power has often acted as a bone of contention between the center and state, because for example, Bihar ordinance making power of the governor was recess its session of the legislature, and the governor extended its ordinance in every 6 weeks, 6 months plus 6 weeks, and every recess was not making a governor's ordinance. Okay, so governor passed more than 600 ordinance during the 14 years of legislature. Okay, sorry, I think 1400, yes, 1400 on 6 years. Okay, so what is the conclusion? To promulgate an ordinance of the president or the governor, the power to make ordinances holds the potential for positive impact by promoting order and addressing immediate concerns. However, it must be exercised with careful consideration of individual rights and community needs. And balancing regulation with fairness and accountability is crucial to ensure that ordinances serve their intended purpose while respecting the principles of democracy and judiciary or justice. Yes, so remember this. Okay, and next is the basic rights. Basic rights, there are various basic rights such as liberty and freedom. The liberty, what is liberty and what is freedom? Under liberty, the state of being free within society from oppressive restrictions imposed by authority on one's way of life, behavior, or political view. So remember this liberty definition for upcoming prelims 2024. And what is the freedom? Freedom means the situation in which a person has the power or right to speak, act, and think as one wants. So liberty means complete uh, freedom. Okay, complete uh, free from complete restraint. Okay, and freedom has some point of restrictions, but liberty does not. Okay, and next is and what is civil liberties? Civil liberties is a fundamental right. Civil liberties are the fundamental rights given under Article 14 to 18: right to equality, right to freedom, right against exploitations, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. So these are the fundamental rights. Okay, and what are the objectives of civil liberties? The secure equal rights, establish political democracy, uphold supremacy of law, protect weaker sections, and create a sense of responsibility. And what are the importance of civil liberties? Civil liberties promote material and moral protection, and civil liberties justiciable in nature, part of the basic structure of the constitution. These are the civil liberties which are part of the basic structure of the constitution, which cannot be abrogated by the parliamentary amendment. And civil liberties put a check on state and private individuals' actions, and civil liberties act as an indicator of the democratic stability. What are the issues related to civil liberties which are exercised in the ground or the any public institutions? And civil liberties are neither absolute nor immune from constitutional amendments. Okay, yeah, and gaps which are given in the basic structure of the constitution, but they are not absolute or nor immune from constitutional amendment. Parliament can amend Parliament can amend these civil liberties which are not given under the basic structure of the constitution. And civil liberties gaps in the enforcement of laws, restriction of state liberties via state action. For example, the creation of ninth schedule which are not immune from the judicial review, and infringement of civil liberties. Okay, infringement of civil liberties by the individual or state action, and non-appreciation of reasonable restrictions by the citizens. So these you can remember about the civil liberties. What are the way forward to strengthen these civil liberties in the society as well as state action? The development of positive liberty, that is the state should aim to create the necessary conditions for individuals to achieve self-realization and ensure that the government follows its obligation to safeguard people's welfare and avoid laws which infringe upon these liberties and freedom. An independent judiciary for meaningful recourse on violation of civil liberties and encouraging civil society and media in order to make protection of liberties and freedom of fundamental political values. So remember this. So here I can end the lecture, and next I will making a video on next section, that is right to free speech under these basic rights. So next basic right is right to free speech. So here I will end the lecture. So thank you for watching. Have a great day.